is summoned to appear, they have a right to a defence, right? Everyone. If the jury decide they're guilty, that's fine. They're not guilty on behalf of a company or a corporation or the country. They're guilty, if found guilty, for one thing: the charges that they're obviously here to answer for. And based on the charges they're presented with, they then are accountable and again sentenced accordingly. So basically you hold them accountable only for the charges there, and you think about any punishment, and that's down to the jury to decide. What's happened, this is a all going to run through just now, in relation to the process we're at just now. We're going to convene the cases shortly, but what's happened is all the defendants haven't responded, haven't obviously written, put an affidavit in, there's no pre-trial conference, so they haven't appeared. Now technically, and again this is to the rest of you, as far as they've done, or what they've done, a plaintiff has lodged a case against them. The plaintiff has said that they are committing a criminal offence. These individuals have not rebutted it. They've not defended it, anything. They haven't actually asked to see us, they haven't asked to speak to us, they haven't actually made the effort to defend themselves. Now effectively, if they're not defending themselves, are they guilty? If they don't defend themselves, fine, doesn't matter. But again, that's to be taken into consideration, because following procedures, you have to think about the consequences. If there's a court hearing just now and they haven't rebutted anything, this is, you then say, right, okay, are we confirming their guilt? Well, technically, yes. But the point is, you have to do that. You cannot just turn automatically and say they haven't appeared, so they're guilty. It doesn't work that way. This is common law. This is not their system. Forget their system. This is basically common law. It's common law courts. So what you do is say, right, okay, have they rebutted anything? Have they defended it? No, they haven't. So therefore, if they don't defend it, and there's plenty of evidence against them, should they be held guilty? Well, yeah, if they don't defend it, they're guilty. So that's fine. But we don't do that, because what we then do is say, well, hold on a minute. The plaintiff then has to tell us what happened. So the plaintiff will put forward the information. When they put forward the information, the jury then will look at the evidence, the information, and they will have the opportunity to ask one or two questions. So when they ask the questions based on what's been put before the jury can then decide, yes, okay, if they're guilty, but based on the information, they can then make a suitable judgment. So they then have the authority to deal with that. But the plaintiff still has to go through the process to put forward the case. As I says, it weeds it out and it makes sure that it is valid and that the jury are happy with it. What also happens is basically it gives you protection and it makes sure that the system we have is lawful. The other thing we do is we have 12 jury members. There's no point in having a decision which is split even 6-6 or 7-5, it doesn't matter. At the end of the day, someone's guilty or they're not guilty, and it has to be that clear. Each and every one today attending here today, I can turn around and say, look, this situation's happened, how do you feel about it? You'll all have an opinion. But when you go to a common law court and you're claiming this is something that will affect other people's lives and you're giving a verdict, you have to know that they're guilty. So basically, most people, it says in everyday life, it says will sit down, be able to assess a situation, look at information and reach a reasonable decision. So they turn and say, well, yes, they are guilty, and you can do that. So what we've done is say, right, okay, this is the people, it has to be done properly, it's honourable, so what we're going to do is say, right, are they guilty, yes or no? There's no doubt. If the jury finds them guilty, they can only do so with a unanimous decision. Without that, they're not guilty, and that's it, end of story. Now, the only way the decision by the jury is final and it's binding, you can't appeal it, that's it. Because obviously it's a decision by the people, you can't obviously appeal it. The only way that it can be retried if there was a major defect in the flaws. If someone has tampered with the jury, it's on the jury, it should have been on the jury, or if there was obviously something that happened to the evidence that was presented or had been docked or something which is major and it would have had an effect possibly on the outcome, you can then retry it. Again, it seldom happens, but it's something that can be done. Other than that, the process will work. It's the jury makes their decision and then the adjudicator will then confirm the decision at the end, and then hopefully, if there is a decision, will then enforce it. And that's pretty much it. That's how it works. Now, if obviously, hopefully that's explained just about everything. I appreciate people may have one or two answer questions which we could do later on. We're going to be here, but what we'd like to do is we'd like to proceed just now and would like to explain what's going to happen. He says, you pretty much know what's happening, but if people wish to take part, we're going to explain roughly what's happening during the day, and then we'll proceed with the hearings. We're going to pretty much have 3 hearings, as I says, 1 in here, 1 through the House. Now, what we're going to do, because we're running them at the same time, we need 5 court officers for each one, so that's 10 people, and again, ideally, we need a jury of 12 people for each case, so that'll be 12 here and 12 through the House. Now, again, what we can do is turn around and say, if anyone is directly involved in the case, by directly involved in the case, meaning, well, it can't be the plaintiff because the plaintiff will be presenting the case. Other than that, this is a direct family member, husband, wife, partner, mother, father, child, they cannot take part in the jury. So apart from that, it doesn't matter, anyone else can take part in a jury. The only thing being is if you're convicted of murder, but if you're in murder, you should be inside and you shouldn't be here. The other thing being is, unless you've got a really good lawyer, the other point being is if you have been convicted of fraud within their system. Now, while obviously I appreciate it's difficult, but obviously if you've been convicted of fraud, you shouldn't actually be on the jury. So that is obviously would rule you out. Other than that, anyone else can volunteer. We would obviously say ideally it's people above, probably 16 above, obviously because we then turn around and treat people as an adult after that, so they can take part. Other than that, that's it. Now, I'll probably introduce you to Neil, will come forward in a minute. He said what we're going to do is we do have a couple of adjudicators. Now, what we've done, we've spoken to 2 people. These 2 people do not have anything to do with the actual case. Okay? They don't take part in the proceedings as in the jury or anything, but they're going to obviously conduct proceedings. Now, the individuals have been selected, or we've spoken to them simply because one thing, they've been involved in the process a little while, they know about the procedures, and they have a firm understanding of what's required. So basically, we have a couple of adjudicators we'd like to put forward. Now, we can't actually turn around and say we're doing that if someone objects. So if someone believes that they can be an adjudicator and wish to put their name forward, that's fine. But we actually have a couple of people on hand to do it. They're not taking part, but they're just conducting proceedings. If nobody has an objection, we'll do that. And then pretty much what will happen is when we set up the hearings here, Neil will obviously, a colleague at the back, will actually be working between the 2, making sure everything's okay and just assisting with that. But the court officials are going to be dealing with everything today. Okay? What we'll do is when we select the individuals, and a final point is we're selecting them just now, and basically we'll see how many people are interested. We're hoping to get everyone up at the same time, and when we get the people here, I said we'll sign the paperwork and do things. There'll be a slight break, maybe 10-15 minutes. If you wish to go to the toilet, fine. We'll come back in about 15 minutes, we'll commence. The jury members and that will stay. However, what we're going to do is probably require the individuals here. We cannot, unfortunately, dictate, if you wish to be a jury member, a court officer, we cannot turn around and say you can put your name forward for a specific hearing, right? For a class action, we can't do that. Basically, it's to be impartial. So if what we're going to do is call forward people just now as court officers. So when we get the court officers, we'll have that, and there'll be court officers for a hearing. So we'll get 2 sets. We'll get 2 sets of jury members, and then when we do that, literally in a flip of a coin, we'll decide one jury will stay here, one will go through the House. The case that's proceeding here is the class action for the children. We have one, this is case number 2, it's regarding a property dispute, this is which we know the paperwork's already issued and ready to sign. So as I said just now, in a flip of a coin, if you wish to take part, you may be in a jury here or next door. We can't actually promise anything, and we can't put you on specifically one or the other. The full verdicts will be given at the end of the trials. This is everyone will know about them when they go on the website, so there's not a problem there. We'll have a break probably afterwards, and we'll have this food and that laid on, so we'll get something later on, which is great. We'll tell people what's happening regarding enforcement, and we will have a 3rd hearing. So unless anyone has any questions, I'll maybe pass you on to Neil, who will take over. Has anyone got a question just now that we start before we proceed? Yes, no, thank you, great, oh, I'm good. No, no, right, question, shout out, I'm sorry, I can't hear you. Okay.
What kind of regrets has the defendant if he's not actually hearing you cause himself?
Yeah, sorry, well, what the question that came up just now, sorry, I apologise. There's that many things to go over, I did miss out one bit. Literally what happens, if someone has been summoned to attend, right, You're attended, if you're summoned to attend everywhere you summon, you attend, that's it. They've been summoned by the common law court. Now, effectively, we can appoint an officer. We can actually go out and grab them and take them in here. We're not doing that. It's not about that. He says basically they've been served with a summons to say, look, you have to answer for these crimes. We're giving you the opportunity to do so. They failed to do so. Now, if the individuals had submitted an affidavit, right, what would happen is when we appointed everyone, the plaintiff would read out the case, we would have an individual here from the public would read the affidavit into the record. Now, they wouldn't be answering questions because they don't know anything about it, but someone would stand up and read the affidavit. The jury would then have to decide what relevance they gave it because the individual didn't appear to answer questions or to testify. So if they had submitted the affidavit, someone would read out that to go onto the record, and it's then up to the jury what they think. Unfortunately, nobody sent in an affidavit. So the fact that they haven't done that, they have no defence. So basically it says whatever's been told, they've been found guilty. People have been found or charged with committing fraud and various crimes. They haven't appeared, they haven't rebutted it, so that's it, they've no defence. So basically there's no defence. Now, that being the case, the jury then deal with it accordingly, but what would happen is if they put the affidavit in, you respond, they don't. If they were to turn up here even at the last minute and say, look, I'm sorry, I'm delayed, I'm the defendant, that's fine. They would actually sit in on the hearing. So what we would do is the plaintiff would present the case, the defendant would sit there. They have no defence because they failed to comply with the procedure, so they cannot offer a defence. However, because they're sitting there, the jury members can ask them questions. So basically, if a plaintiff says they've done X, Y or Z, the jury can't actually say, right, we need clarification, and they can ask the defendant. So the defendant could only answer questions by the jury. They haven't appeared, so they can't do that. And because they haven't submitted an affidavit, there's no defence. So we can't even read in the affidavit for record. So there's no defence, that's it. So that's it. Now what happens, because they failed, the people will find them as either guilty or not guilty and then pass sentence. They have no redress. They were given the opportunity. They have been served with the papers. They have chose to ignore it. Now, when they're ignoring it, right, this is the important part. They've ignored this, right, and we've guaranteed they've been served, that's fine. But they're not actually ignoring to appear here, right? What they're actually doing is ignoring this process. They're refusing to accept the authority of the common law court, right? They are refusing to accept the authority of the people, right? That's you. So hypothetically, they've been summoned to appear on guilty charges or crimes that they're guilty of. The charges they're guilty of, or they would be guilty of, is against the people, right? So they're committing crimes against you. They're not even attending to defend themselves, right? They do not accept it. Now, you actually pay their wages. If a jury finds them guilty for the crimes, that's the end of story. And then we just deal with enforcement. They've had an opportunity to rebut it, an opportunity to put in a written affidavit, an opportunity to have a pre-trial conference, or they can even attend today. They've refused all that. It's not the refusal to come here. They're telling you that they're not interested. Couldn't care less. And in the courts, they pretty much say, look, we don't accept common law. Well, it's not a matter of accepting. It exists. We're the people. We'll deal with it. So these people have chosen and said, no, I don't accept it. We're not interested. We're not dealing with it. And because if they come in, many of these officials, many of these individuals are officials in government positions. If they come in here, it's an acceptance of what we're doing and they don't like it. They have to acknowledge in court because we presented the documents, so they accept the documents, but they don't want to accept it. In fact, what is said, word for word, by more than one judge, they says, right, what we have in this country just now, currently operating is two judicial systems. We have the common law court, which convenes its own courts and issues orders. They also issue documentation, meaning birth certificates, etc. He says, we understand that. However, that's got nothing to do with us. We're not interested about that. We deal with the statutory side, and these are statutory rules. And that's it, and they just proceed accordingly. But they can't do that. But basically, they have said there's two systems, but under the system here, they are answerable as men and women for what they've done. Now, it says if you have umpteen people within the, again, it's just something that happens. If somebody has done something, they're incompetent and negligent or criminal, if they're in a position they've been found out, what normally happens is they're protected by the state. They're protected by the state, and if it's really bad, they'll actually be moved from one position to another, or they'll be pensioned off. But they don't actually get sacked for uncharged with anything. They don't get charged, they don't get a criminal record. They actually get told, no, that's unacceptable, right, you'll have to leave. So they dismiss them. But with the dismissal, they get a very, very lucrative bonus, and they get a huge pension. And they're committing crimes, and they're not held accountable. Nah, that's wrong. Everyone's held accountable, anyone, for their own behaviour. The common law court is the only one that does so. The state doesn't do that. But basically this is how it operates. And as I said just now, if the common law court give a verdict, we proceed, they've had the opportunity, the people then decide whether or not they're guilty, and if they're guilty, they pass on the sentence, and it's down to the court to enforce. And that's it, end of story. Okay? It's all right. Yeah? Okay. Gentlemen?
Balance of probabilities, is that recognised in common law?
It's what recognised.
When the judge passes,
Yeah.
you can receive reports.
I might be able to help out a bit, John.
Yeah.
The balance, I find on the balance of probabilities, it's when you lose the case.
Well, again, this is they use things like that as fine, but basically, again, we're dealing with one of the cases we're going to speak about anyway. We can't actually go on to do that. But basically, the system they have a system set up that they use. The cases that are being brought forward today are to deal with disputes regarding the behaviour of individuals within the statutory system. Now, basically, they do things, they play by their rules, but bearing in mind, the plaintiffs today have said, well, no, what they're doing is actually criminal. So basically what the cases will do today will explain the process, part of what you just discussed just now, the behaviour, and then the jury will decide what's happening. I can't actually come up other giving you basic information about the procedures of what's going on. I can't comment on that. I'm not even sitting on the jury. But the point being is it's down to you. Now, if the state behave a certain way, if they believe that obviously based on the balance of probabilities or their rules or what they want to do, this is what they're doing. So a case is presented to the jury, and the jury then decide. You're the authority, the people. The people decide whether this behaviour is acceptable